Before the Administration of Criminal Justice Act was passed in 2015, it was clear that there were problems with the administration of criminal justice system in Nigeria. Describing the problem aptly, in 2011, Honorable Justice A.U. Kalu, who has risen to become the Chief Judge of Abia State, wrote, "It is my surmise or view that the magistrate or judge cannot reflect positively on the judgment of his fellow countrymen when he is performing his judiciary functions on the basis of a trial or case management strategy that does not permit him to dispose justice efficiently, effectively, and speedily. That is a challenge which we must all commit ourselves to overcome." Following this statement and clamor from the public and concerned lawyers, the question arose as to who was going to do something about the ailing administration of criminal justice system in Nigeria. It began with the National Working Group established in 2004 by Chief Akin Olujimi, Senior Advocate of Nigeria, as proposed by Mr. Wale Fapunda, who later became the Attorney General of Ekiti State. The group was chaired by Mr. Chinoya Obiagu, working with Professor Yemi Akincheye George, Senior Advocate of Nigeria, as the Secretary. Owing to budgetary constraints of the Federal Ministry of Justice, the group was supported by the MacArthur Foundation. Though the bill was developed by the National Working Group, of which Lagos State was a member, represented by Mr. Fola Arthur Worry, Lagos State was the first to pass the bill into law in 2007 and then revised same in 2011. Because of complexities in the federal system, moving forward with the bill was slowed. Chief Baya Ojo, Senior Advocate of Nigeria, who succeeded Chief Olujimi, Senior Advocate of Nigeria, as the Minister of Justice and Attorneys General of the Federation, continued with the reform. However, it was Mohammed Bello Adoke, Senior Advocate of Nigeria, serving in the office of the Attorney General of the Federation, that established the panel on the implementation of justice reform. This panel was headed by Honorable Justice Ishaq Bello, a judge of the Federal Capital Territory High Court, who later became the Chief Judge of the Federal Capital Territory High Court, provided the guidance and leadership for the reform process. Professor Yemi Akincheye George, Senior Advocate of Nigeria, also served as the Secretary of the Criminal Justice Reform Subcommittee of the Panel on Implementation of Justice Reform. The Center for Social Legal Studies, presided over by Professor Yemi Akincheye George, Senior Advocate of Nigeria, was the platform which provided technical assistance to the Panel on Implementation of Justice Reform with the support of the MacArthur Foundation and the British Council. The Administration of Criminal Justice Bill was sponsored in the House of Representatives by Honorable Dr. Ali Ahmad, Chairman of the Justice Committee. Senator Umar Dahiru sponsored the bill in the Senate. Owing to a delay in the Senate, Mr. Didi Dodo, Senior Advocate of Nigeria, intervened and personally prevailed on the leadership of the Senate to get the bill passed. The bill was signed into law by President Goodluck Jonathan on the 14th of May 2015, just a few days to the end of his administration. The act has been hailed as a revolutionary piece of legislation and lauded as the most important intervention in the criminal justice system since the independence of Nigeria. The highlights of the act include, but are not limited to: 1. Bringing uniformity to the criminal justice system by combining elements of the old Criminal Procedure Code and the Penal Code. 2. Creating clear criminal justice objectives focused on ensuring that the system of administration of criminal justice in Nigeria promotes efficient management of the criminal justice institutions, speedy dispensation of justice, protection of the society from crime, and protection of the rights and interests of the suspect, the defendant, and the victim. Focusing on a restorative and rehabilitative criminal justice system as was part and parcel of the African traditional system in the pre-colonial era. 4. Providing for advanced criminal justice statistics and data management, and focusing on the prevention of crime. 5. Encouraging a technology-aided justice system and gender parity. 6. Prohibiting the stay of proceedings in criminal trials via the avant-garde Section 306. The Act also seeks to ensure compliance with human rights, control of pre-colonial detention, and automatic review of remand cases, imposition of timelines on officials of the criminal justice agencies for performing stipulated functions, mandatory reporting requirements, sentencing guidelines, and modern plea bargaining guidelines. The Act has been adopted by 31 states of the Federation, with few modifications tailored to benefit each state. Lagos State has now updated their own version to take on the several innovative provisions of the Federal Administration of Criminal Justice Act. The Center for Socio-Legal Studies is grateful for the support it has received from several stakeholders and development partners, which has made the message of the ACJA possible. The MacArthur Foundation has continued to support the implementation of the Administration of Criminal Justice Act and the various Administration of Criminal Justice laws of the various states by working through the Criminal Justice Reform Cohort. This cohort comprises the Center for Socio-Legal Studies, the Legal Defense and Assistance Project, the Center for Law Enforcement Education, Partners West Africa, the Nigerian Bar Association, the Nigerian Institute of Advanced Legal Studies, the International Federation of Women Lawyers, and last but not least, the Campaign for Democracy. All of the fine patriots of Nigeria who contributed in one way or another to the passage of the Administration of Criminal Justice Act cannot be recognized in one account. Their efforts and contribution, however, were fundamental to the passage of the Administration of Criminal Justice Act and paving the way to a modern criminal justice system in Nigeria.